Today's Above the Bar, we're going to be delving into a serious subject, an unfortunate one, divorce. You guys have been together for some time, and it's just not working out. You've discussed it with friends, with relatives, a religious leader, maybe even had some marriage counseling, and it just isn't going to work. There's a lot of questions that come up. Divorce is a serious business, just like getting married or having children. So what are the steps involved? Who gets the house? Who gets the car? Who gets the bank account? Who gets the kids? There's a lot to consider. It's a serious situation, divorce. Our own Nikki Israel discusses this with two prominent matrimonial attorneys in New York, Irina Lust and Anna Carli. So let's listen in. I'm Bob Ward, and this is Above the Bar.
I'm Nicole Israel, and today we have a great show for you. We're joined here by Anna Carli and Irina Lust here in New York, and we're here to talk about a very important subject today, and that's the topic of divorce. Now, many people are affected by divorce in any which way, but just for the basics. So first, how do you get a divorce in New York? What are some of the available options, and how long does it take?
In New York, you can actually obtain divorce based on about 6 grounds. There are contested divorce grounds and uncontested divorce grounds. What is contested divorce? Is when one of the spouses tries to get a divorce based on adultery, if the other spouse committed adultery, if the other spouse is in prison based on imprisonment, or it's a cruel and unusual treatment, if the other spouse is treating you, or the spouse actually applying for divorce is being treated cruelly at home. And also there's a conversion of a no-fault conversion divorce. And since October 2010, New York is one of the states that recognizes a no-fault divorce based on irreconcilable differences. If a married couple had irreconcilable differences during their marriage for 6 months or more. So therefore, these are the grounds that you can use to obtain a divorce in the state of New York.
Okay, now you say uncontested divorce may become contested.
Absolutely.
Now, are there any requirements for uncontested divorce?
Let me tell you a little bit about uncontested divorce. Contested divorce usually takes about 1 to 3 years, and in outrageous cases it could be 5, 7 years. But uncontested divorce, as opposed to contested divorce, is where both parties, both spouses, actually agree on all issues prior to filing the divorce. They usually agree on issues such as child custody, child support, maintenance, equitable distribution of their property, assets and liabilities division. But basically both parties have to agree right away, and then divorce is uncontested from inception, which means parties do not have to appear in court, so they save money by not going to trial, by not spending large amounts of money on appearing in court before the judge. So it's actually a very good option, but if the spouses can agree. And usually uncontested divorce, depending what county parties reside in, would take from 4 months to 1 year. For instance, in my experience in Manhattan, it usually takes about 4 to 6 months, which is not so bad. But in Brooklyn, it takes about a year, sometimes a little more. So it's better to file in Manhattan if you can, if you qualify. And the thing with uncontested divorce is sometimes it becomes contested when another party, another spouse, becomes hostile and cannot agree on some issues and says, okay, I changed my mind. So then the divorce becomes contested, which is more costly for people. So in such a case, what I would say, what you should do, you should discuss with your spouse before filing for divorce whether you would agree, and figure out if I should be doing uncontested divorce. If you know that your spouse has a propensity for being vicious and will try to be against you and fight you on every little thing, then it's probably not a good idea. So to qualify to be able to file uncontested divorce, parties must have resided for at least 1 year in New York. Then parties must agree on which ground of divorce, which ground they will be using. And Anna mentioned all those 6 grounds. And usually no fault for uncontested is most usual divorce, ground for divorce. Then parties have to agree on child custody, child support, and it has to be within guidelines of New York State. For instance, 1 child it's 17%, 2 children 23% of combined parents' income. And then parties also have to do equitable distribution, basically dividing what is separate property, what is marital property, and Anna will talk about it a little bit later. She'll explain what that means. So, but basically you divide what each spouse has, and that will govern an uncontested divorce.
So just to clarify, are there any circumstances where uncontested divorce is a bad idea?
Yes, so like I said, if your spouse is vicious and will fight you, it's not a good idea. You wouldn't want to spend money. Also, if there is domestic abuse, it's not good because abused spouse will not be on level playing field with perpetrator. So it's really not a good idea. Abused spouse should get help and should get somebody advocate for their rights. So I would not recommend uncontested divorce for them. And another thing, if parties are ignorant about law, they just don't know what they're doing, that might not be a good idea.
Okay, just the last question about uncontested divorce. Can both husband and wife be represented by the same attorney?
Absolutely not. We do not recommend that because there could be potential ethics issue and conflicts of interest. What usually happens, one spouse is represented by an attorney, parties agree, and then another spouse just signs acknowledgement of service, signs appropriate papers, but does not appear, and this becomes uncontested divorce and it goes on. So another spouse does not need to have an attorney. They can, but then it will be contested divorce.
Okay. So just a highly contested argument for contested divorce, I guess, would be adultery. Now, how do you go about proving adultery?
Yes, that's a very interesting question because proving adultery is not an easy matter in New York. In New York, adultery is considered a voluntary sexual or deviant act by one spouse with another person, not your spouse, during marriage without consent of the other spouse that's not involved. Mm-hmm. So adultery usually requires some evidence to prove the actual act of adultery. And this is really hard to obtain. So the other spouse who's trying to file divorce based on adultery would have to hire probably an investigator or somebody who can help the filing party to obtain some facts of adulterous relationship. And there are also defenses to adultery. In New York, for instance, there's a defense of collusion, meaning that the other spouse that wasn't participating in adultery either asked the spouse that was adulterous or encouraged that spouse to participate in an adulterous act. Also, there is a defense of what is called, acceptance of adultery of some sort, that after the adulterous act, the adulterous spouse tells the other spouse that the act occurred and the spouses have sex and everything seems fine. So that could be a defense to action based on adultery for divorce. Also, there is a defense of the spouse who files for divorce also being adulterous with somebody else. So the spouse filing for divorce based on adultery, also having a relationship with someone else outside the marriage during the marriage, cannot use adultery as a ground for divorce. And also, it's very important to make sure that if you're filing for divorce based on adultery, you have good evidence to support your claim, because a simple claim of a plaintiff that adultery occurred is not enough. You need some extra evidence to prove it. Also, your defendant admitting the adultery is not enough in the state of New York. At the same time, you have to show that there was a propensity to commit an adultery, that there was opportunity to commit adultery, and the opportunity could be shown if the adulterous spouse, for instance, went into another party's home with whom they supposedly committed adultery at 11 p.m. and didn't leave that home until 8 a.m. If you have this kind of proof, that could show that they had the opportunity to commit adultery, but the simple showing of opportunity is not enough, so it has to be also that the other party has a predisposition to do that, meaning somebody saw that the adulterous spouse to be holding hands with the person they committed adultery with, or some public show of affection towards somebody who is not their spouse would be some kind of additional evidence that is required in the state of New York.
Okay, and then just on another topic, you mentioned before about marital and separate property. Now, how does that play out in a divorce proceeding?
That's also a very good question. Marital property is any property in the state of New York that a spouse has accumulated during marriage. It be it spousal real estate or wages that the spouses earn during marriage. But this is a default position under the statute. Anything that's not covered by a prenuptial or postnuptial agreement. So here, answering your question, I will not be assuming that the couple has a prenup or a postnup, what's called the contracts that also may define how spouses dispose of property upon divorce. Separate property is anything that either one of the spouses may have prior to marriage, anything that you own prior to marriage, anything you receive as a gift during marriage, inheritance that you receive from your relatives during marriage, and also anything that you buy with the property that you held prior to marriage or held during marriage, but that was separate. However, having said that, separate property may become marital property if it's commingled. So a party during marriage or spouse has to make sure that the separate property stays separate and is not commingled. For instance, if one of the spouses had a business prior to marriage and having been married for a while, the other spouse decides, I will help you in the business, and the business actually increases in value or makes more money, and the participation of the other spouse is significant or somewhat significant, that that business now may be considered marital property, so that the lines of separate and marital property have been blurred in that situation. So it's very important to distinguish the property, and that's done by the courts after filing for divorce. And that's the court's job to distinguish and find out what property is marital and what property is separate. And at the end of divorce, that property is disposed according to the law.
Okay, now sometimes there are children involved in divorce proceedings. So for that, how is child support calculated? How is alimony calculated? What are the rules in New York for that?
Yes, child support in New York is also statutory. The calculation of child support is a formula, pretty much. Usually, if a combined spousal income is $80,000 or up to $80,000, then what occurs is that number is multiplied by a percentage that's indicated in the statute, and the percentage is governed by how many children the couple has. If a couple has one child, then the 80,000 is multiplied by 17%, and then that number is split between the parties according to how much they make, according to their share of that combined income. And that's how child support is determined. If a couple, for instance, has 2 children, then it's more than 17%, and it goes up to 5 or 6 children. Mm-hmm. So that's how child support is calculated in New York. Also, if a couple's combined income is above $80,000, the court does the initial calculation, but at the same time, they consider the extra income that the spouses have. And that during those considerations, the court looks at And the court looks out for the best interest of the child. And doing that, the court looks at child's needs, the lifestyle that the child is used to, maybe the school that the child goes to and how much it costs, and different other aspects of the situation. So the court basically is governed by the necessity to provide for the child and for the child's or the children's best interests. Also, there is such a thing as maintenance in New York. Maintenance could be temporary or permanent. Maintenance is something that a spouse gets either during the separation prior to the divorce proceedings or after the divorce, and that's permanent maintenance, I'm sorry. And temporary maintenance is a formula also by the statute, and some considerations that come in is the income, obviously, if the spouse stays at home, if the spouse is a full-time mother, if the spouse didn't hold a full-time job for a while or a part-time job, and so on. In the permanent award, a maintenance award after the divorce, they're also considered such factors as how long the spouse was taking care of the children, not working and staying at home, and what is the age of the spouse, and what are the things that the spouse needs to do to maybe get back into the work market, such as maybe continue her education or his education, or get a higher degree, and how long it would take for the spouse that was staying mostly at home taking care of the children, for instance, to get into that work game and be more employable or be employable at all. So these are the factors that go into the award of maintenance in the state of New York.
Okay, and just switching topics once again, the idea of a prenup. Now you hear about this with a lot of celebrities. Can you describe what exactly it is and when someone who's considering divorce, when they are getting married, if they should get one or not?
Yes, I would like to tell you more about prenuptial agreements because there are usually so many myths associated with prenuptial agreements. First one is that you have to be wealthy, you have to be Donald Trump, Tiger Woods to have one. Actually, nowadays, people get married 25, 27, 30 years old. It's pretty early. So down the road, you accumulate funds, you accumulate assets, you earn degrees. So 10 years down the road, 20 years down the road, you end up with owning a house, having a couple of bank accounts. So you might want to protect that. You should anticipate that you will be making money in the future. Or you might go and get a professional degree, such as, CPA or lawyer. And in New York, actually, professional degree can be considered marital property. So if you went to law school and you were married, and later you get divorced, your spouse can say, look, I supported you during law school, I helped you, so now your license is divided, and I will be getting profits from you working as a lawyer. So and a lot of people don't know about it, so it's very important considerations if you are working towards a high degree. Mm-hmm. Another myth is that, you really have to have a prenuptial agreement when you don't trust someone, or you have concerns, and it just shows, a lot of people think that it just shows mistrust, and it's not romantic to talk about prenuptial agreements, and they're reluctant to even start the conversation with their potential future spouse about it because they could be embarrassed, they would think it's not common, or they're just not educated enough about the process. So which is, we encourage our clients before they get married to enter into prenuptial agreement because actually it helps spouses to become closer. Because what happens, they have open communication about their finances, about what they have, about what their plans for future are. And they just basically, you find out all this information and they can reasonably, amicably decide what's reasonable and what's fair. And in future, if one of them gets divorced, you have a sense of security, you have a sense of stability, so you know that down the road it will probably, most likely, will be amicable. So it's a good insurance, and I would recommend for couples to at least consider it and talk to each other and find out what our expectations about financial future for each of the spouses are. So those are the myths. So what I would say, clients come into our office and they say, well, why do I need a prenuptial agreement? Why? So usually we give them a whole list of reasons. One of the reasons is you're opening new business. you might open your business. And again, appreciation, even if you open your business before you get married and later on your business grows, appreciation in value will become marital property. And you might have partners, so you might want to protect that, and partners might want you to protect the business. So that's one consideration. Additionally, a lot of people nowadays have other children from previous marriages. So you would like to protect your children. So in case you get divorced, inheritance and some of your assets going to your children and not everything going to your spouse. So that's very important. Additionally, again, licenses, businesses, any ventures, and just in general prenuptial agreement, you can define a lot of things in the prenuptial agreement, but there are some things you cannot talk about. And you cannot define rights of third people in your prenuptial agreement.
But child support can be modified once an order for child support has been entered in some sort of way, either by pursuant to petition or motion by one of the parties, or otherwise. And it can be modified when, for instance, the spouse or the parent that's paying child support has a change of luck, and, for instance, the income of that parent has decreased significantly. So in that case, you need to modify a child support order. You need a change in circumstances, a significant change in circumstances of a paying parent. So child support can obviously be modified to increase it or decrease it. And to ask for a decrease in New York, pursuant to the law that just came out in October 2010, there needs to be a show of a drop in income of 50% of a drop in income of a parent who's paying the child support, for instance. And to increase child support, there needs to be a show that the parent who's paying child support is making significantly more, a good amount more than before, or if the needs of the child have increased because the child has gotten older and there's a need for health insurance, or there are some health issues, or education requires more higher payment of child support. Or, for instance, if the custodial parent who is receiving child support has a change of luck and the custodial parent's income has decreased significantly, then the application for child support modification is warranted, and then it will be given by the courts. But it has to be done officially by a motion, and we always recommend to retain an attorney for this kind of legal work, because obviously child support is important, and obtaining an order reflecting the necessity of the child is what a lawyer will do best.
Okay, so what if a spouse is involved with some sort of malicious financial maneuvers on his part in business? How is the innocent spouse, I guess, affected, or are they?
Yes, actually it happens all the time in our practice. So basically what we do when the client comes into the door, we sit down with the client and we go over both spouses' financial situations thoroughly. It's very important for us to have complete and full disclosure. And it's also very important, we can down the road in our litigation, we have discovery tools that we can find out that information. But it's very helpful, it's very preemptive to find out complete situation before even divorce starts, because then we can plan for malicious looting of the assets. So what we usually do, if both spouses have credit cards, we could advise them to lower the credit limit, or we could possibly even advise that they cancel the credit card altogether if they suspect that the other spouse will run up high credit and high debt. Additionally, if spouses have joint investment accounts, it's very important for us to look at all investment accounts and then make sure if another spouse is prone to looting it, we might notify a financial institution and tell them to freeze the account. Or we may call the financial institution and tell them to have each spouse sign for any transaction they do, every single transaction they do. This way we know there is no looting of assets. And it's very important to give us insurance information, bonds, stocks, IRS, everything you can come up with. Because then we can say, okay, you have this asset, so here is the preemptive attack, just trying to make sure that the other spouse doesn't take it from you. But very often what happens when we don't have complete disclosure, when another spouse is really vicious and manipulative, things happen and assets get wasted. So under New York law, you can actually have a couple of tools that helps you to deal with dissipation of assets. So first, what courts usually do when there is dissipation of assets and we prove it, they would take equitable distribution, they would take the remaining assets and award the spouse that didn't loot the assets more money, more property, more assets. So basically the guilty spouse will get much less. Or for instance, if the spouse is seeking maintenance, spousal support, but they at the same time have been looting the assets, then maintenance award will be reduced as well. And additionally, you can also apply to court for temporary or final order asking to stop another spouse from dissipating the assets. But it's a very real topic and it's very important to deal with it at the outset.
Is there any way to deal with it in the prenup, or is there a way to bulletproof the prenup just to make sure it's solid?
Yes, to bulletproof the prenup, you have to make sure that it complies with all the formalities. Basically, prenup is created in the same way the deed is. You have to have acknowledgement, you have to have all the signatures, and
Witnesses as well.
Witnesses, yes. So it's very important that you comply and have to sign on each paper. And it's very important that you follow those formalities. Courts are very strict. If you don't follow those formalities, this agreement will not be valid. Additionally, it's not recommended to enter into prenuptial agreement too early to the date you're getting married. Because very often courts would look at the prenuptial agreement and the time when it was signed, and they would see that, well, it was entered 10 days before parties got married. And they usually, most likely, they would say it's invalid because there could be some duress, and another spouse can come out and say, okay, there was duress, it was not rational, I didn't have a lawyer. So people should avoid that. You should do it in advance, you should plan in advance.
Unfortunately, we're out of time. Nikki Israel, thanks as always for your great questions. Irina Lust and Anna Carly, thank you so much for participating and being guests in this show. We really appreciate it. And if you find yourself needing to get a divorce, make sure you get a qualified divorce attorney. I'm Bob Ward, and this is Above the Bar.